Morning. Some of us are at 1 o'clock here. Other ones are around the 10 o'clock hour back in British Columbia and throughout Canada. I just want to welcome you to the Money Saver, Canadian Money Saver webinar. And today we're featuring Colin Ritchie. Colin Ritchie is a fee-for-service lawyer, financial planner, certified life underwriter, and a financial plan management planner. It's a lot to say. Today he's here to talk to you about estate and will planning. He's based in Vancouver, British Columbia.
And I guess the rest is up to me.
The rest is up to you.
Um, First, it's my pleasure to spend some time with all of you this morning. And of course, a big shout out to Canadian Money Saver for making this happen. And also my thanks to you for taking the time to attend. I thought I better explain a little bit about, because I even get confused about myself sometimes. So I'm a lawyer, and I focus on estate and financial planning matters, which means wills, drafting trusts, powers of attorney, and other estate planning documents such as spousal loans. On the financial planning side, I'm fee for service, which means I don't sell you products, just my time. And I don't sell products, which means that I don't have to defend one company's particular product over anybody else. I've got no vested interest in either slamming what you have or getting you to stick with something that's not appropriate. I can work with people that are already on your side, and you decide how to use me. I can be somebody who can just give you advice on one or two big issues that you're dealing with right now, or if you want some help on a regular basis, I'd love to help you with that. If you want to know more about me, my website's at the end of the presentation. That's the final slide. So let's get going on this, because I'd much rather talk about estate planning than I would about myself. The way I look at estate and financial planning in general is like chess for money. There's a lot of different pieces on the board, so you've got a choice of what your options are, and you have a choice as to what order you move them in and where they actually go. And if you do things just right, you can have a huge difference on the situation and the outcomes for your clients and your family and your friends. So it's very rewarding, but it's also very mentally stimulating and challenging. Well, since I am a lawyer, I thought you'd be disappointed in me if I didn't have some sort of disclaimer. And so here it is. The big one is, this is general information. Estate and financial planning is complicated stuff, and it's very situation specific. So I would love to give you some great general information, but the reality is every situation is different, and you're still going to need some advice from your lawyer, your accountant, somebody who's handling your stocks, investments already, before knowing what the exact right thing is to do in your situation. Yes, I am a lawyer, but I'm a BC lawyer, so I can't give legal advice to any of you folks from out of province, although we're still going to talk about a lot of the things that are going to be important to your situation as well. The other reality is things change. So I'm going to give you some advice and some information today, but the reality is a couple years from now, I don't think everything will be completely different, but there's probably going to be some big changes. For example, as some of you might know, they've changed how they're taxing some of the trusts that I'll be talking about later in this presentation that people set up for their kids on death. It was done for tax reasons in the past, but now the government is clamping down on that. So anyway, life and laws change, so you need to keep on top of these things from time to time. So here's the general agenda of what we're going to be going through today. This is Estate Planning Bootcamp, so we're going to talk about a bunch of different estate planning things, and hopefully they'll all tie in together, and you'll be able to get some good general information on what's right for you. So one thing I will say about estate planning is it's not just having a really good will, and I'll explain some of the other tools in your toolbox that you can use to accomplish what you want to happen when you die. I'll explain a little bit about how people get taxed, at death and some of the ways that we can keep the bill as low as possible without doing any hard time for tax evasion. I'll also try to clear up a little bit of the mystery of probate fees. For some of you out there in provinces like Alberta and Quebec, this is a complete non-issue. I think in Alberta you're dealing with $400 in fees versus Quebec, it could be 0 or 99 versus BC, which is of course what I'm most familiar with, which is about 1.4%. So no flat fees in BC. Well, there is a fee, but you've got to pay a percentage on top of that, and it's about 14,000 per million. So we'll talk a lot more about that later, so I won't get distracted. But for those of you in high probate provinces like Atlantic Canada, Ontario, most of the prairies other than Alberta and BC, a bit of probate planning can save your family a bunch of cash later. I also want to talk a little bit about blended family planning because the rules are different. It's quite simply the rules are different if you are in what's so common these days, a family where both or one partner comes from a previous relationship where there are kids. All the things that work really well when it's just a traditional family where all the kids are both of your kids might not be the solution when there are a completely different cast of characters involved. I'll also talk a little bit about trusts that you can set up in your will and a little bit outside your will as well. A lot of people don't do this, but if you've got a life insurance policy, and you can do this with RSPs as well on the second death, it's possible to get the same control and tax benefits for your heirs that you can get by doing the same planning in your will. So I'll say a bit about that. And finally, I want to talk a little bit about wills in general. I'm very passionate about that. Before hanging out my own shingle a few years ago, I was a director of estate and financial planning at Sun Life in BC for almost 10 years. And in addition to traveling all over the province and working with insurance advisors and the better clients, I had the opportunity to review a lot of other lawyers' wills, and there are some good wills out there, absolutely. But I saw a lot of things that could have been done, in my opinion, a bit better. So I want to share some of those things with you. So if you have a will that's not up to snuff, you can take the appropriate action. And if you're somebody who's just getting a will done for the first time or was going to get one redone anyway, that you know some of the right questions to ask and some of the extra ingredients you can add to the sauce to improve your result. Oh, the other thing I should say is we're on for an hour. I'm not tied to that hard and fast. I realize everybody's got a busy life, so I'm going to shoot for an hour, but if it goes a little bit longer, that's fine. I would love to get your questions, but the reality is I can't answer them as we go. So what I'd propose is if you can type them in, Alana will be able to vet those for us and pass them on to me. I plan on spending at least 15 minutes after we go through the meat and potatoes of the presentation to talk about those. If we don't have time to address all of those today, I'll try to follow up with answers to some of the other questions as appropriate a little bit later. So that's what I propose we do, and next let's do it. So estate planning, the way I define it is trying to come up with a game plan in advance to accomplish the goals that are specific to your situation for when you're not around. And it's vague because it's not one size fits all planning. There's a lot of different goals that people have. Some of them conflict with others and some are self-evident. And everybody's situation is different as well. So what is the right estate plan for you might be completely different from the guy who shares the desk with, or your neighbor, et cetera, et cetera. So we'll talk a little bit about some of the goals and considerations that figure into estate planning so you can help realize some of the things you can accomplish and realize that sometimes there's opportunity costs that go along with trying to achieve some goals as they might conflict with some of the other things you might want to happen. And the other thing I want to stress is your will is a huge part of the plan for most of us, but it's not the only game in town. Having a great will makes a huge difference, but there's 5 or 6 or 7 or 8 or 10 different other things you can do, depending on your situation, outside of your will to increase the chances of success. And by success, I mean accomplishing your goals, keeping most of your family members actually talking with each other, and making things as simple as possible. In terms of estate planning goals, to me the most important one is making sure the right people get the right amount at the right time. And by that, what I mean most commonly is if you've got kids, we want to make sure that they're adequately provided for. We want to make sure that they don't get too much too soon. And we want to make sure that they're protected from themselves. So for example, if you've got an 8-year-old kid, what I would probably want to do if I was working with you to do up a will is to set up a trust for that kid so that somebody's making the money decisions for them, not only until they're the age of majority, which is kind of what's required in most provinces anyway, but until they're much older than that. Because as I like to say, would you want to give somebody $1 million check on the first day that they're legally entitled to drink? Doesn't make much sense to me, and I don't know many parents it really sits well with either. Also, sometimes in blended family situations, you want to make sure that everybody gets something right away. You want the new spouse to be taken care of, but maybe the kids from a previous relationship need some money now, and there's no guarantees that your new spouse would want to take care of your old kids. So that's another situation that requires some extra planning. Next goal is administering your estate. Most people want it to be as easy as possible for everyone else. It's still a crappy job. Don't let anybody tell you otherwise. And with all the emotional trauma and upset that goes along with it, it's having to do a crappy job at a time when you're probably not at your best. So a lot of people, especially those who've had problems with their own family and friends administering estates, want to ease the burden on everybody else. So when it's their turn, things are as pleasant as possible under very tough circumstances. Another goal is making sure that money gets to the right people soon. In other words, we don't want money tied up in estates for 2 years while lawyers are figuring out who it really belongs to. If you've got a spouse and kids, especially young kids, they need the money now. So one of the goals, even if there is going to be a bunch of complex planning, is to make sure that at least some of the money is going to be there for the nuclear family's immediate needs over the next month, 2 months, 3 months. So while they're going through this tough time, they're not worried about how they're going to pay the next mortgage payment or tuition payments for the upcoming school year. Another huge one is avoiding the family conflicts. I'll talk a little bit more about that later. But there are so many things that can go wrong. Even if you think things are great now, a lot of times when there's a few dollars on the table, things can get a little bit awkward. Of course, a big one, and one that's of course warm and dear to my heart as a financial planner as well as a lawyer, is keeping the tax bill as low as possible, both at your death and also for your heirs going forward when they inherit what you've left behind for them. Not breaking any rules, but taking advantage of the rules that exist. And sometimes it's having a great will, but a lot of the times it's going to be doing planning even decades in advance to cap the amount you have to pay in taxes. So anyway, we'll talk a bit more about that in a section. And another one that's really important is not just protecting young kids from their lack of life experience and youthful exuberance, but also protecting maybe kids who have bad marriages, who've got creditor issues, who've got mental health issues, um, who are disabled, who are just really, really, really bad with money. And once, don't worry, we're not quite done with the estate planning goals yet. I could do an entire separate presentation on small business planning and, of course, farm and succession planning as well. I actually have a blog article that's going to be published over the next week or so that's going to talk about some of the business planning options out there. I also put out a blog the other week on just wills. So if you do check out my site, be sure to look at that, because I'm hoping that that will supplement some things we're talking about today. And if you're like me, sometimes you need to read rather than to listen, and maybe add a little bit of context to what we're talking about right now. So I said your will is not the only way when you're setting up your estate plan. Let me explain what I mean with that. One of the most common other ways of getting the job done and getting the right amount to the right people at the right time is beneficiary designations. In other words, if you've got life insurance, you've got a pension, you've got an RSP, you've got a RIF, you've got a TFSA. If you have life insurance products, like a segregated fund, which is like the life insurance industry's equivalent to a mutual fund, or types of annuities that life insurance companies can sell you. And by the way, all annuities aren't necessarily pensions for life. They allow you to name a beneficiary for those assets right on the product. That's great. The problem with that sometimes is they're asking you to gift $1 million by ticking off a box on a one-page form. You've done all this work putting together a will that's, well, I won't tell you how long some can get, but 15, 20, 30-page wills aren't uncommon. You've planned for what happens to the money so kids don't get too much too soon, but despite all that hard work and good work that you've done in your will, it's possible to still create a big problem if you've just ticked off a box saying that if my wife isn't around, my 2 kids get the $1 million of insurance. You might even have ticked off a box that says my sister will watch the money while they're minors. But the reality is, when the kids turn 19, they're still getting that big check. And they've got no handcuffs or restrictions on what they can do with the money. So a lot of good estate planning is taking the extra step with your registered plans, with your life insurance products, so that you get the same checks and balances over that you've got over the rest of your estate. One of the other things that I'm really passionate about when I'm talking about beneficiary designation planning is making sure that the right people don't get left out. For example, if you've got a life insurance policy and you've named your 3 kids equally, your kids are all in their 40s or 50s. That could be great if all of your 3 kids are around when you're not. But say one of your kids has died before you and there's grandkids on the scene. If you've just checked off the basic box on your insurance policy and said, to my 3 kids jointly, what would happen would be the 2 surviving kids would keep the whole $1 million. And those grandkids of yours, whose parent is no longer around, would miss out on splitting over $300,000 between them. So I like to make sure that you've planned for the what ifs for your insurance money and your RSPs as thoroughly as you've planned for what to do with your house and your vacation property, your non-registered portfolio. So it's just making sure that you put the same amount of time into the insurances and the RSPs as the rest of your estate. There's also joint tenancy planning, which can work really well, but it's really tricky, and you have to get good legal advice on this. What I mean by that is a lot of times people want to avoid the hassle of paying probate in provinces like BC, Ontario, and the Maritimes, as I discussed earlier. By having assets owned in multiple people's hands with the right of survivorship. Don't worry, I'll explain what probate means in a second because I think I need to in order to make the rest of this comprehensible to you. Maybe I'll explain probate now. Probate is a process where a judge looks at a will and says, great, this is valid. And then the judge issues a letter that the executor can take to the bank, to the investment company, to the land title office, to the motor vehicle bureau, that gives the executor the authority to do all the things that the will says he can do. And that's the letter that gets things done, because the investment companies, the banks, won't transfer money without this letter from a judge confirming the validity of a will. The thing to remember is probate's a wonderful thing because it lets the right people get the right thing and get the money that they deserve and the assets that they need. But it's not required. So there's no obligation for you to have to file probate. It's just a way of getting the banks and the insurance companies, well, maybe not them so much, but the investment companies to release money to you. But for things that are owned jointly, it just happens. You don't need to get this letter from the court. And so there's a huge potential savings on probate fees. The problem with joint tenancy planning is it can create immediate tax problems for the people added to title. It can create unnecessary tax bills for the deceased estate, and it can create some really ugly will battles, or at least related estate battles after somebody's died. And I'll tell you why very briefly. First, on the tax side, if you add somebody as a joint owner to your house, for example, you're living there, and the kid you add has his own home, if you don't have the right paperwork in place, the CRA will treat the kid's interest in the home from the date the kid goes on title as something that's susceptible to capital gains. If you own the house yourself and you keep it that way until you die, there's the principal residence exemption in Canada, which means that there's no tax, there's no capital gains owing on the value of your house, no matter how much it's grown. But by having the kid on title, and if the kid has their own home, the portion that the kid owns will be subject to those capital gains from the time the kid goes on title till the time the kid sells. So yes, maybe you've solved the probate problem, but you've created a tax bill for the kid that could have been avoided. And on top of that, the place is now susceptible maybe to the kid's creditors. If the kid gets divorced, her husband might try to make some claims against your house. And if you ever have a falling out with your kid, or maybe your kid has some substance abuse problems or mental health issues and goes off the rails for a little bit, you've lost control over the place you live. So anyway, if you do the joint tenancy thing, you need a document in place to confirm a bunch of things. One is that your house is still your house as long as your kid's alive, and your kid is just on title for your benefit. And the kid has to give the house back to you anytime you want. And if anybody sues the kid, it doesn't matter because it was never the kid's house at that time anyway. And the really nice thing is the CRA, if you have the right letter in place, will agree that it's still completely protected under your principal residence exemption. In other words, if you're a surviving widow and you put your only son on, it doesn't matter how much the property goes up in value from the time your son goes on title. His half of the property is still going to be tax-free at death because it was never really his property at that time. The other really important thing to do when you're doing this joint tenancy planning is to make sure that you say what you want to happen after you've died. You might have a document saying, and the document's called a bare trust agreement. A bare trust agreement. So if you haven't heard that before, it's something that maybe you should hear about going forward. It says that the kid is holding it in trust for you while you're alive. And of course, you can do this for bank accounts and investments as well. But it doesn't say what happens at death. And around 2008, 2009, the Supreme Court of Canada looked at these things with new eyes and came up with some new rules as to what they want to happen in that situation. There's two possible additional outcomes. It could be that the son you added on title, to use the example we had before, who didn't really own anything while you were alive, now becomes the complete owner of the whole property to do with as he wishes. So that's one possible outcome. But another outcome is the son who is on title for probate purposes while you're alive is also the executor of your will, and you've got 3 other kids. It could be your intention was for that son to distribute it to his siblings or their relatives under the terms of your will. So in other words, you weren't giving it to your son during your life, it was for you then. And at death, it's not really his either, it's for him and all the siblings. And the courts say that they have to figure out what you wanted to happen for each case. And of course, as you might expect, if you've died, it's not uncommon for different family members to have different views about what you were trying to do. So it's really important to have documentation saying who is to get the property at death. Is it supposed to be the joint tenants who've survived you to keep, or are they just holding it on behalf of your estate? So if there's one area in particular that needs legal help, this